Hey everyone, it is really wonderful to see so many of you here today. This is a very timely webinar with the UK government's consultation into AI copyright closing just last week. And we've obviously hit on a really hot topic as there are so many of you here. Thank you for joining us. So if you don't know me already, I'm Emma. I'm one of the co-founders of Spark AI. At Spark, we're on a mission to help creative agencies, brands and marketing teams like yours lead the way in the AI era. And we do that through training programs for leaders, for designers, for strategists, and running events like this one. And our guest today is Alexandra Ralph from the Creative Rights Institute. Hi, Alexandra. Really great to have you here. Would you like to introduce yourself?
Hi, everyone. My name is Alexandra. I am the founder and director of policy at Creative Rights Institute. To give a little bit of background on myself and the company, I come from media and entertainment, previously from music and entertainment law. And I've most recently started to specialize in AI, and especially the policy landscape and kind of regulation side on AI, especially when it comes to the creative side of things. I've worked in previously in larger media companies, especially on AI policy pipeline, as well as risk mitigation and governance. And most recently, as I founded Creative Rights Institute, this concentrates on, especially on the analysis of policy legislation and the kind of the regulatory landscape internationally when it considers copyright and protections on the creative rights, and as well as the media law itself. So that's my overall background.
Thank you. You're perfectly placed to be talking to you today. So thanks so much for being with us. I'm just going to remove the holding page so that you guys can see us a bit more. We've got about 45 minutes today. So Alexandra and I will chat for around 30 minutes. And then I just drop any questions into the comments on LinkedIn, and we'll try and answer those either as the topics come up or at the end. We'll see how it goes. Fab. Okay, I will do my best to keep an eye on the time and make sure we address as many of those points as we can. If not, we'll answer them afterwards. So let's get stuck in, shall we, Alexandra? So at the moment, like, why do you think AI-generated content is creating so much confusion around copyright and intellectual property rights? There's so much noise about it on LinkedIn, in the media, why is it creating so much confusion compared to just like other types of creative assets?
That's a really good question, and it is really true. It's kind of, especially amongst the noise and constant kind of publicizing of the most recent legislations and cases and shifts in policy, and this kind of arms race that we're currently seeing amongst the European, Chinese, and the American territories is kind of really making it hard for everyday operators to kind of understand where it's all leading and what it means for them on kind of day-to-day basis. And I would say the kind of the core issues kind of creating that confusion around copyright and intellectual property rights is that that AI generated content challenges the traditional copyright principles, which always assume and are based on human authorship. The UK law is currently somewhat ahead of its time, in a sense that it grants copyright on AI generated works under Section 9, subsection 3 of the CDPA, which is currently under the government review, which is computer-generated works, which assumes authorship if no human involvement is.
Alexandra, the CDPA is the current copyright law. Is that right? Yeah.
That's right. Yes.
Yeah.
It's the copyright. Yes. From 1988, and it's the kind of overarching copyright regime that the EU applies to copyrighted generated works. One of the other aspects is obviously uncertainty of ownership, which is, we're going to be touching on that, which is that who's the owner of the generated works? Is it the AI tool provider? Is it the user, or the creator of the AI model itself? And obviously AI tools are often trained on copyrighted data without explicit permission, or and currently is raising some concerns about infringement concerns, especially if you guys have seen the most recent campaigns around Make It Fair, which is the musicians and artists putting their foot down against this. And then the third one, which is one of the largest one, which is that there's no global standards. Different jurisdictions such as the EU, the UK, and the US have different ways to interpret AI copyright, especially because there's also kind of deviation within the original policy on copyright itself. So it's very hard to kind of understand how one law applies within another jurisdiction when the provider is based in another country. So those are the kind of overarching themes that are currently creating quite a lot of confusion around the copyright and intellectual property rights.
Yeah, and I think you're right. I think there is confusion around it compared with like existing copyright law, and I think. Do you think there are like some real misconceptions mixed in there as well around this topic? Do you think there's some myths that need busting while we're here?
So some people, obviously, some people who might not be as adverse to the conversations might think that AI generated content is automatically copyrightable, and that's not the case always. Just because there's the element within the Copyright Designs and Patents Act of 1988 that states computer generated works, that doesn't mean that it's automatically applied. It's currently the kind of language, as well as the phraseology used, is that it may be entitled copyright protection under this act. So that's one of the misconceptions. The other one is that AI tools create original content, and the unfortunate reality is that AI is trained on existing works and could inadvertently copy a pre-existing work that is copyrighted, that the service provider, in this case the AI tool, has no right of infringing on. And then the other one is if AI generates something, it belongs to the user. Some AI companies might actually claim rights over output in their terms of service, and this is especially for commercialization purposes. So for personal purposes, it might not matter that much, but if you're aiming to commercialize that content, then that creates another layer of issues. And then obviously, AI training data is always legally sourced, and that's false, as we've seen that many of the AI models are really scraping copyrighted content without consent or permission from the originating authors of those works. So those are the ones that I've kind of put down, but there's a myriad of more, but these are kind of the ones that really kind of hit the nail in the head.
Yeah, that are grabbing the headlines really. And I wonder if, before we sort of go further into the conversation, whether we should just like clarify what UK law currently defines as ownership, like right now, because I know the consultation's just closed, and like I guess, and what are the key like ambiguities that agencies and marketers need to be aware of right now?
Yes. So obviously, as I mentioned before, under the CDPA, which is the Copyright Designs and Patents Act of 1988, has in Section 9, subsection 3, states that copyright owner of an AI-generated work is the person who made the so-called necessary arrangements for its creation, i.e., for instance, the user prompting the AI to generate a certain piece of content or text or video or whatever the output may be. And then, as you said, the UK is actively reviewing whether to keep, amend, or remove the Section 9, 9 subsection 3, meaning the law could really change, and this could actually mark a completely new era for the UK copyright regime, in terms of its kind of functionality within the larger UK economy, as well as IP protections. UK is a massive IP producer, worth over billions and billions of pounds with an annual revenue for the economy. So it does have quite overarching and wide implications to the larger economy as well. And as said, copyright protection applies only if the AI-generated work meets the originality threshold, and this is where we're really getting to the legal gray area, because that's a very it's very gray in saying what meets the originality criteria, and especially when you toss in AI and a machine that goes from point A to point B without us understanding how it came out to that conclusion, it becomes even more kind of um, uh, ambiguous to understand where you can consider it to be original enough to be deserving of copyright protections. And one of the exceptions, as opposed to normal copyright, which is 70 years, the term protection for this is only for 50 years from creation. So it's shorter by 20 years after the so-called human author's death. And the final thing is that there's no clear case law yet that really defines who qualifies as the owner when there's multiple parties involved in generating AI content, i.e. The user, the licensor, the generator of content, as well as whose content has been used to be trained. So those are the kind of overarching issues to kind of look out for in terms of the current state of the law.
Yeah. So just to like summarize that, just to make sure I've got it right. So if an AI is like straight out of the machine, it's not protected. It's not protected by copyright. But so we need to have a human must contribute like creative input and choices through human thought to it. But there's a grey area around how much, because there isn't any case law about it yet.
Exactly. Yeah. And for human authorship, usually what we previously over the last decades under this copyright law, it has been quite kind of obvious in the sense that when you take the necessary arrangements for, let's say, for music or human authorship, or even photography and so forth, it's been pretty straightforward to understand how the human authorship works, unless it's infringing intentionally on someone else's work without kind of attribution or acknowledgement. Whereas in AI is very much what we call the black box. Is we don't really understand 100%. Firstly, what content it has trained itself on, and second of all, how it ended up in that final kind of final point of spitting out that final image or prompt or whatever, which kind of results in the issue of not understanding, is it original enough in its own to be copyrightable. And then usually what you want to do is you want to start doing amendments on the basis of that and make it original enough so you can claim it to have copyright, so it's distinctive enough from the final end result of what the machine produced, so that you can kind of sigh of relief and say, okay, there's this enough in this. But then again, it's a legal gray area, and there's no case law yet that kind of completely gives us clear guidance on that.
Yeah, absolutely. So we're just in this strange sort of interim, uncomfortable period before
Very
it's
much.
Yeah.
And the powers are the paradigms and the powers are shifting, especially because we as much as we hate to admit it, it's especially in the UK now that we've seen the way EU is moving, the way US is moving, and China is moving. These socio-political as well as socio-global impacts are really having an impact to the way government is deciding the regulation. If it's deciding to put protections of copyright over innovation, or if it's more interested in driving innovation and fostering that collaboration innovation within the UK borders, and being placing copyright as more of a secondary issue, and kind of sacrificing some of those aspects for the betterment of competition in the global area. So it's very much kind of not only impacting the way these countries do and consider regulations, but also the way it's being highlighted on the global stage as well.
Yeah, it's so interesting how political it's become, and I'd like to touch on that a bit more actually later in our conversation. But before we do, I'd just like to sort of just go back to I guess get back to the basics of like the tools that we use, because some of them do scrape the copyrighted material without permissions, don't they? And some of them don't, like Firefly and Getty, and I guess just what should agencies or in-house marketing teams be like aware be aware of when they're using tools that use the copyrighted data that they've taken without permission at the moment? And what kind of legal risks might there be?
Yes. So in terms of kind of going into what to look out for is,
in fact, we have a slide on that, don't we?
I think we do. Yes.
I'm going to add it to stage while you're talking about this.
Amazing. So I've created this kind of AI tools checklist. So whenever signing up to, there's a few routes when especially kind of engaging with these larger companies, such as Stable Diffusion, Midjourney, ChatGPT, and not larger service providers. And the first thing I always kind of recommend is firstly, before signing up to any subscriptions, whether it be off the shelf or whether it be a commercialization agreement or master services agreement with the service provider, is to always kind of take a step back and understand what you're signing yourself into, and what rights are you waiving, what rights are they waiving, what does this say in terms of training, ownership, data mining, further training, is it an open model or a closed model, and is somebody able to see your generated outputs? Are they able to generate similar content based on what you produce as well? So I've kind of jotted down 5 different areas, which is the legal and copyright safety. So looking out for what ownership guarantees are being given. Are they free from any copyright claims? And especially looking at the license training data, what are they stating that they've trained their models on? Then obviously wanting to look at the transfer of IP rights, as well as the indemnification clause, which is a really important one. And obviously you want to be lookout, especially for UK-based companies, you want to be on the lookout for what jurisdiction and governing law it will apply with disputes. So obviously it will be a lot harder, for instance, to adjudicate something somewhere in Indonesia, whereas if you're based in the UK, because those laws are applied in a different manner and a different way. And then obviously opting out on any data retention, and understanding what data they're retaining, where they're retaining it, and how long. So for instance, when you if you decide to close your account, you want to be looking out for how long are they hanging on to that data for, and what that data is being used for. And you obviously want to be disclosing any kind of transparency issues, is what disclosures of training sources they have put, if they've put any, because they don't understand if there's clear labels to avoid misrepresentations on AI, as well as then obviously usability, which is obviously modification of outputs, usage limits or restrictions, as well as the licensing of these integrations. So you always want to be looking at also, does it grant a specific license for you to commercialize that content? Sometimes it states that if the company is big enough that you need to have a special license to be able to commercialize as well as to utilize these content. So those are kind of the top areas to always look out for before you sign up to any service provider or any tool, just to understand that you're not potentially signing away or waiving your rights, as well as putting yourself in a very unfavorable position if there's any issues that may arise in the future.
That's such a helpful, really helpful practical checklist. Thank you for putting that together for us, Alex. Just while sticking on the kind of like practical nuts and bolts stuff, we often advise agencies, keep records of their key prompts, particularly for client outputs. Would you recommend that too? And like, I guess why? Could you talk a bit more about that?
Yes, I always advise whatever content you produce within AI tools, it's always good to have your content backed up. So for instance, in previous cases, I've told and informed on policies saying that you need to, whenever you use these tools, is that you make sure that you don't delete any content at the end of the week. For instance, on your ChatGPT, download the chat log, and just store it somewhere safe, in a separate folder or a separate location, as well as obviously, if you want to really go into that due diligence and kind of really make sure that you're basing your kind of grounding in law to be more kind of solidified is obviously record your prompts and your secondary prompts, is to understand is those are key, because usually if there's, God forbid, ever if there was any kind of issue that was arising, it's to kind of be able to refer back that you're not trying to intentionally infringe or potentially exploit an artist's work or copyrighted work that the output was generated from. So I would always recommend to keep that evidence safe and keep those logs safe, so that you can always refer back to them, and it doesn't become an issue of matter of hearsay, essentially.
Totally agree. Yeah, and that's a really practical, easy way to do it. Just at the end of each week, like you advise. Yeah.
Exactly. It's always, I understand that for a lot of companies who generate a lot of prompts, especially agencies, recording manually each and every single prompt might be a bit of a task and a half. So if there's a way for you to download or just get a generated kind of a log of all the context and text as well as the outputs, you can always keep that safe, and that could be always that kind of base of evidence for you, just in case to back up your claims.
Yeah, I agree. But also, sharing prompts within your team is also a really good thing, just for learning and upskilling and all of that good stuff too.
Exactly,
Yeah,
and I've recommended prompt training for a lot of people, because not only has it become an art, but it's also becoming that kind of key to unlocking kind of security and safety for yourself, is to always understand that, like, certain prompts when taken in context of saying generate me a Disney character, that's a massive red flag in itself. Some people who are getting started might not know that, or they think that it's harmless. But again, it always goes down to damages. So whenever you start commercializing content, and if that is really based on that prompt that you outright tried to create something from a copyrighted content, then it does become a legal issue. So prompting is something that I think a lot of companies have and will start to look at in terms of training and instilling mandatory training as these tools become more readily available for the larger workforce, and it starts being applied to the kind of everyday areas of our works.
Totally. And even if you choose not to use AI, it's so important to understand what it can do as well. It's to have that side of it.
Exactly. And because ultimately you're directing it to do a task, and if you're saying do a task, create a song that sounds like Michael Jackson, it will do that task, but it won't always understand that the implications itself, unless there's any restrictions being placed on specific prompts.
Yeah, and it's quite interesting how the temptation seems to be more with AI to use prompts, including in the style of type things, and it referencing something that we know well, something that's copyrighted, and I guess it's no different than asking an illustrator to do a drawing of something that's copyrighted, and we wouldn't have done that before. And it's interesting how it's different psychologically with AI to that temptation.
Exactly.
But please,
a lot of
don't
emphasis.
do it on client work, everyone. Yeah. Fab. So I wonder if we could just go back to, we were talking a bit about the politics earlier, and just touch on how the different regions, the US earlier this year released their guidance on AI copyright. The EU taking quite a different tack. The UK is hedging its bets at the moment with consultation, and but we think it might go more perhaps towards the US, because that's where politically we're leaning, or we were yesterday, maybe we're not so much today. It'd be really helpful if you could just outline, put some more kind of detail on how those different regions are approaching AI and copyright regulation. And I guess, are there any lessons from other regions about how we as agencies should learn from that, and for working with clients in different places?
Yeah. So there's kind of like the three-prong approach that's currently going, and the one that we really don't know where we're currently exactly just heading is UK. The European Union was the first kind of federal or governmental institution to instill a comprehensive um, uh, act to regulate artificial intelligence amongst its borders. And the fundamental kind of approach that EU is doing is mandating AI transparency, and and especially kind of when it goes down to disclosing training data sets or copyright outputs for copyright owners. And obviously there's what they're doing is they're doing a risk-based approach. So there's certain applications and certain tools that are considered high risk, such as, for instance, considering using HRs using um, AI tools to shift through CVs.
Right.
That because as we know, there's coded bias in all the tools we make. That there's certain elements and underlying risks that EU has outlined that that these tools are not allowed to be used for, and certain tools that they're not allowing within in their borders. So they're very much kind of doing a risk-based approach that UK is considering. Whether UK is going to do it is another thing, because one of the, I guess, the downsides of this is AI companies generally don't really enjoy a a surrounding that has overarching regulation. They kind of really want to just innovate, innovate, innovate. And it's really, really useful up to a point, because if you don't put these safeguards and mandates in place to ensure that these tools are developed ethically and safely, then that does kind of induce a new layer of risks, as well as a potential harm to users. Um, so what I've seen most recently, especially after the Paris summit, is I saw that President Macron has kind of stated that this is a slight issue, that there's a lot of confusion amongst companies within the EU on what that means to them and how should they base themselves when it comes to AI, especially fostering AI within the borders of European Union. It's not really, it's not going the greatest. Companies aren't really opting to choose to base their locations in Europe for that reason. So they want to be reducing burdens on smaller businesses, and to ensure that they're not kind of placing a burden of regulation onto these businesses that potentially just completely tie their hands and leave the European Union kind of out of the racing game. Then there's the US, which previously had what you call a blueprint of AI rights. And unfortunately, well, not unfortunately, but since there was a shift in government and administrations, US has now completely rolled back on these regulations, and President Trump has been kind of directing large amounts of investment. So the US is now taking the approach of investment and innovation over kind of tackling these issues of regulation themselves. The US still, obviously, the Copyright Office is still outright said that AI generated works don't deserve copyright protection under the Copyright Act of 1976, which is the federal law, or the equivalent of their federal law, our CDPA law. And there's still quite a lot of ambiguity, and there's a few legal cases to be on the lookout for, to see how this kind of adjudication is starting to now occur in courts in terms of infringement. And
like they're going to start to indicate to us what might, as these legal cases go through.
And that leads me to the UK, which is which is kind of, as you said, the consultation period is now considering the copyright on kind of three approaches, which is option A, which is do nothing, and leave it as it is, and then kind of see at a later date as things progress on what's happening. The option two, which is allow an exception for AI companies to have access to publicly available data and train those data sets. And then those copyright owners whose works are out there publicly have the chance to opt out if they so wish. But this obviously induces a question of burden for people who have that content out there and who don't want to have it trained on. So we don't really have a framework like that existing currently, so we don't really know exactly how would that happen or what that means. And then there's the third option, which is allow the exception to the training data, but only if the author has granted you the permission to train on their content. So currently, it's looking like the most preferable option seems to be option B. Whether that's going to happen or not, and to what extent, we're not still 100% sure. The UK government is very much kind of holding its cards close to its chest to just kind of see which way it's going. But you can kind of see that, especially now that there's been this public consultation period, things are very much starting to move now. And it's going to be very interesting for the next few months to understand what it's going to roll out, if it's going to be sector specific. So if we're going to have our sector specific regulators such as Ofcom and other agencies kind of regulating that within these kind of industries, or whether it's going to be a more kind of government-centric approach, which is that if it's going to be a unified law such as the EU law, or if it's going to be the US law of kind of what they're doing is kind of also a lot of state-to-state variations of protections. So these are the kind of most fundamental differences. And what agencies might want to be on the lookout for is obviously depending on where your clients are based, and depending on where you're doing your business. If your area of business is predominantly UK, you mostly want to be concentrating on seeing what is happening, what the UK law is going to be kind of stipulating in terms of AI. But if you're working on projects within the EU, within the European borders or the US, it's really pertinent to understand, firstly, what agreements you have in place with your clients. So to understand, for instance, if these transfers of rights of content that you generate for your clients are going to be in their ownership, or if it's only licensed, and what that means in terms of their specific laws in those borders, because they do differ. So this is where the kind of fragmented approach really starts kind of digging into companies, is not understanding that you might have protections in this country, but you might not have protections in this country.
It's very complicated. And after this webinar, we're going to put together a bit of a cheat sheet on this, exactly for people to have for reference during this kind of grey area at the moment. We've got some questions coming in, that's great. But just a reminder to please get your questions in. I'm going to ask a couple more questions and then we'll go over to you guys. Alex, I wanted just to touch on the Getty Images versus Stability AI case that's coming through, because that's, I guess, it's going to be like one of the first cases that starts to give us some I don't know, some guidance on where things might go. Because is that in the UK? That's happening.
Yes. So Getty Images was sued Stability AI for using millions of copyrighted images without permission to train its AI models. And one of the most kind of visible parts of this was when AI was spitting out images where it had the water stamp or the watermark of Getty Images, and And that was kind of one of the points that I was saying that, well, listen, you see clearly that it's generating content that's being copyrighted and has the watermark from Getty Images. Potential outcomes. So we're looking at the court dates are currently being arranged for the summertime. So we're gonna start to see some action during the kind of early months of June, early weeks of June, to kind of see what's going to happen in the court. But potential outcomes, if Getty wins, uh, AI companies may be forced to obtain explicit licensing from data training data. So this might actually introduce a potential new precedent within the UK law and common law that where AI companies, if they want to train on, let's say, specific images, specific music, or anything else, you might actually have to seek exclusively a license from the company itself to be able to train. And this could also restrict the AI-generated image tools, as well as affect agencies using AI for commercial work. But then again, if it wins, if Stability AI wins in this case, it could then very much mean that we're looking at a complete new era of kind of copyright infringement cases. So it's kind of what's currently being said within the lawsuits and these consultation periods within the High Court, has been that, this is representing hundreds of artists, even though these artists might not be exclusively involved in the lawsuit. They're still being represented by Getty's lawyers, and it becomes instrumentally harder to obtain undeniable proof of underlying copyright infringement, because we again don't know what the black box does and how it lands within that one conclusion. Obviously, yes, you see some elements like the Getty watermark, but then again, that alone doesn't always prove outright infringement. So it might induce a complete new kind of strategy that lawyers have to deploy to start adjudicating these cases of copyright infringement if the UK judicial branches decide that that there just isn't enough undeniable proof for this. And that's where it becomes quite tricky, is that because we don't really know if and how somebody might be able to obtain that. Another good case is Suno and Udio, which are music tools, are being sued in the US by all the major record labels for essentially saying that they've infringed on thousands and thousands of pieces of valuable copyrighted content from the most major artists that we know on this planet. And Uno and Studio are very much kind of now backing their claim, saying that it's fair use. And this is going to be something that everyone wants to be on the lookout for. Is we don't have fair use, but we have fair dealing within the UK under the Copyright Act. So there are certain exceptions that you're able to use another person's work, and those certain rules apply. Whereas in the US, there's what we call fair use cases. And a lot of these AI companies are now banking on this fair dealing or fair use principles within the court, and they're trying to see how far they can stretch that argument. So whether that argument is going to be valid under the judicial eyes is going to remain to be seen. However, it's something that we definitely want to be looking at, because that does induce potential outcomes risky for both sides, however it's going to be. But we're never going to be able to satisfy everyone in this case, because it's very much kind of innovation and regulation butting heads at the moment.
Yeah, probably a really good time to be an IP lawyer right now.
Interesting time. Probably a lot of gray hairs.
Yeah. We've got a great question from James Rosen in the chat. I'm just going to put it on screen. Oh, it's quite long. It's covered us up. But essentially, James is asking about what we think about using generative AI in concepting and ideation stages, because we've talked a lot about the kind of final assets. He's talking particularly from a commercial film production point of view, do the same risks apply if we're just using generative AI to ideate and not making the final cut?
Well, James, that's a great question. So in these cases, usually when you're explicitly talking about ideation, you're and that depends again if you're aiming to commercialize it, and then if what the final end product of your ideation is gonna differentiate from the product that was spit out. But if it's, for instance, what James said, that it won't be used in the final result,
Yeah.
for ideation purposes, it's a lot less risky.
Yeah.
I wouldn't say a lot less, but it's less risky because it's solely for the purpose of trying to generate some ideas that you might be basing your final concept or scripts as well as kind of films based on. So so if it's for internal ideation, these tools actually can be quite useful, but it's always goes down. For instance, let's say that it doesn't get in the final cut. Yeah, obviously, there's not that much of a risk because it's not being commercialized. So so there's that distinction. But it always goes down to then if you end up wanting to use that similar style, what your idea was, then you might want to kind of look at is the kind of reverse image search, or kind of using these kinds of tools that you can detect AI and seeing if what differentiation there is on publicly available content. And then obviously, again, going down to the originality point, which is you might want to make amendments, edits on different tools, and kind of keep enriching the picture or amending it or adjusting it so that it's far enough distinct from the original product that it can be kind of considered as an original piece. So again, but that again is a gray area. But for general purpose of ideation, I think it's a lot less less risky because you understand that this is just something very raw and it's something very kind of primitive. It's not the end result. It's not the final product. So there's bound to be a lot of iterations. And there's bound to be a lot of different amendments and changes. Some tools that don't even apply AI to make the final cut. So so for ideation purposes, I think it's a lot less risky. But then again, you still want to be taking those same protections during ideation stage. Just ensure that if there's, let's say, if it's a tool that doesn't guarantee you that somebody else can train on those images that generated outputs, that you still have those protections kind of in place, like prompt recording and
Great. Yeah, great advice on that, sort of double check back. Which brings me nicely on, because we just have a few minutes left. So I'd just like to start to wrap up, really. So any last questions on the chat, please just add them to the LinkedIn comments and we'll answer those. But Alex, what would be your immediate actions if you were an agency owner after this webinar? What would you suggest to kind of ensure compliance and reduce risk? What would you go away and make a bit of a checklist to do? And we will also provide a checklist too. But what would be your top things?
So the first thing I would do is review the AI tools and data sources. So you want to be looking at what data it's been trained on, is it licensed? For instance, you want to be looking at, one of the greatest things is that now that we're talking about the efficacy, is we're also looking at areas such as Adobe Firefly. And these kinds of companies are doing somewhat of an ethical approach to when it comes to AI and AI copyrighted content, so that giving that peace of mind and ease to the users, where the training data is owned by Adobe. They're closed model data sets, so you can train your own model and nobody else has access to it. Those outputs aren't being trained on any other models. So you want to be kind of looking at if there's a possibility of of using tools where you can use ethical tools where there's a lot less risk and that offer that kind of transparency that everybody's wanting from these companies. You want to be obviously avoid models that use unlicensed copyrighted content. I mean, that's easier said than done. So if you do end up using something like Stability AI or versions of Midjourney that don't offer commercialization agreements, or I'm sorry, master service agreements that guarantee additional protections, then you want to be taking these specific steps of of taking the terms of service as well as the licenses and recording your prompts. Obviously, updating contracts and client agreements. So, revising your internal policies as agencies is going to be important. Which is you clearly want to define the ownership of rights on the AI generated content. Consider maybe including indemnification clauses against copyright claims. So you want to kind of internally maybe have a think with your councils on okay, if you want to end up using AI content that we generate for you, then we're going to need some guarantees on both sides in terms of do we identify each other, and then obviously specify human involvement in the AI generated works that you're doing. You want to implement AI content verification processes. So you want to do your due diligence, so to speak, and try to see if you can use tools for plagiarism checkers. For instance, Turnitin is one of the larger ones that larger UK institutions use. Use reverse image searches to just see how these AI generated visuals, for instance, do compare with other publicly available content, and if that gets flagged up. And as we've spoken before, recording AI prompts and edits and backing them up on somewhere safe where you can always refer back to. And then obviously, educating your internal teams and clients on the AI copyright risks. So, what I was talking about, which is the fair use limitations and copyright law itself, and then obviously constantly informing your clients about the legal status and risks on AI generated content. So if there's any kind of larger kind of shifts within the areas that impact your work, you want to kind of stay up to date and updating your clients on those as well. And that obviously. Training staff for the proper AI prompt usage. So always kind of training them up and upskilling them to understand how you can avoid potential risks within prompting on these tools, and then monitoring legal developments and kind of adjusting your practices accordingly. This is what I've spoken with policy experts in the UK government as well, is that whatever policy is going to be implemented, it has to be adaptable and has to be something that isn't stagnant and that isn't going to potentially just sit there like the Copyright Act of 1988 has been since 1988, and we're now in 2024. What you want to be making sure that it's adjustable and it adjusts to the environment and it adjusts to the constant redevelopment of this technology, and so that the rapid deployment of regulation can be more proactive rather than just reactive. Um, and obviously staying informed in high impact court rulings like Getty Images and Stability AI. Just if you see those articles, it's always good to just have a glance in your eye and just kind of read it through to understand, and then track the implementation of the areas that you work in. So if you work in the US, it's good to just stay up on those sources. And we've included some sources that you guys can look at and sources that you can kind of check up on every now and then. And I'm also, through the Creative Rights Institute website, I do release a policy analysis documents on when it comes to AI, also outside of AI. And then, as Emma spoke, we are actually putting our heads together, Spark and Creative Arts Institute, to generate, so to speak, a creator's guide for 2025 to kind of understand what we're looking at in the next year, next 12 months, and how can agencies and creators alike kind of start to pick this whole thing apart one by one as we kind of go forward.
Oh, Alexandra, that's so comprehensive. Thank you very much. And I've just popped on the screen the great sources that you recommended. You were talking there. So feel free to screenshot this, everyone, but we can also include it at the back of what we put together as well. A question just came in. Let me just take a look and see if we've got time to answer this. It's about what I'm going to pop on screen. What should production companies be checking in regards to AI software that to the AI softwares agencies are using that may be working, but their agencies may be using, basically? What should clients be keeping an eye out for agencies using? We can perhaps Alexandra, we can
answer this in the comments
after. We can answer this in the comments afterwards, so everyone will have access to it. Because actually, we are running out of time. But let's do that. So Julian, we'll get back to you in the comments if that's okay. So let me just work out how to take that off the screen again. Okay, fab. So thank you so much, Alexandra. That was a wealth of information, and I'm glad that we decided that we're going to put something together.
And just a disclaimer to all the listeners, if you feel like after 10 minutes of me speaking, you felt like, whoa, that's a wealth of information, I can assure it is. And if you feel like it's really hard to pick things apart in its current state, you are not alone. This kind of it was quite tricky already towards the end of the year, but especially these kind of political shifts are happening around the globe. It's kind of tossed everything back into the mix. So these, the competent race between these regions and the regulations and innovations and everything, it's now so saturated in terms of the news that we constantly keep digesting amongst other articles and topics, that it does kind of make it hard to keep up with the regulation. But there will be at some point this year a more clarification, especially from the UK government, on how it considers the AI copyrights, and as well as the training data and data scraping aspects, and what individual companies should be looking at. So there will be more clarification. Unfortunately, we're still very much in that gray area where we can't exactly say if it's going to pivot towards point A to or point B, or kind of somewhere a Goldilocks path, so to speak, in the middle. So don't be discouraged. There will be some more kind of guidance, and hopefully this at least kind of opens up a little bit of the areas that you might want to be looking at.
Yeah, I'm really pleased you said that, because I completely second it. It's so easy to feel kind of like you're behind, or FOMO, or like, just sort of, but it is a really tricky transition time at the moment in terms of the legal context of this. We try and keep up to date in our newsletter as well. Just put the QR code up there. Oh, sorry, Alex, did you want to?
No worries. And hopefully the document that we'll be looking out, hopefully the document, or the kind of impact assessment of the next 12 months that we're going to be releasing, will kind of give further information and kind of serve as somewhat of a kind of like a guide to kind of understand these different areas, if there's any kinds of ambiguities or further questions that have remained. So these will be also covered in the document.
Totally. So we'll send that out to everyone that's attended this time, and we'll send it out through our newsletter there as well. And just to wrap up, really, just tell you quickly about what Spark does, which I touched on at the beginning. But we do events like this. We do one sort of deep dive like this a month, and also we have a podcast where myself and my co-founder Jules talk about what's happened that month and what to watch out for the next month. And we also run workshops with agencies on AI fundamentals. So we cover this at a high level in that too. And we run AI accelerator programs, which are a 3-month program where we work with agencies, with leadership, with strategists, with designers, to work through, partly these knotty issues we talked about today, but a lot more about how to integrate AI into agency workflows in a kind of sustainable, authentic way to each agency. I think that's my last slide, is it? Oh no, I've got our next event we have a one-off in-person event in London at Citizen M. It's a really gorgeous venue for agency leaders, which is kind of a Chatham House Rules day, including a delicious lunch where we talk about all this and more. So let me just remove that. And okay, Alexandra, thank you so much. Everyone on this, everyone who joined us, you'll hear from us probably next week, I think, with the guidance that we promised you. And thanks so much for being here. Thank you, Alex.
Wonderful. Hopefully everyone has a great day.
Have a good day, everyone. Bye.
Bye.